Welcome back to the Constitutional Clarion and this series on the Whitlam dismissal. Now, for those of you wondering about the backdrops, I'm in Oxford and these are photos of places that I've recently been. The background, this time, is from the Oxford Union's old library, where I did some work this morning. Now, back to the dismissal. A key development, which really put the idea of dismissal into the political and public realm, was the release of an opinion by R J Ellicott QC about the Governor-General's powers, which Ellicott previewed in an article in the Sydney Morning Herald on the 14th of October. Ellicott had served as Commonwealth Solicitor General from 1969 to 1973, including under the Whitlam Government. He resigned in November 1973 and was elected to the House of Representatives as a Liberal member in May 1974. In 1975, he served as a shadow minister, although he wasn't actually the shadow Attorney General. At a dinner on the 16th of October for the Malaysian Prime Minister, and that's the one where Whitlam joked with Kerr about there being a race to the palace to see who could dismiss who first, the opposition leader, Malcolm Fraser, had a word to Kerr asking him to read Ellicott's opinion. Kerr arranged for a copy to be picked up the following day. While Ellicott wanted to speak to Kerr personally about it, Kerr refused. Ellicott later observed that the point of the opinion was to influence the Governor-General's thinking because the opposition took the view that it was the Governor-General who would ultimately resolve the crisis. Ellicott's opinion, which had been published as a press release, started by surveying the Governor-General's constitutional role. He said that it involves the execution and maintenance of the Constitution and of the laws of the Commonwealth. Now this picks up the wording in section 61 of the Constitution, which makes the executive power of the government exercisable by the Governor-General. Ellicott added that the Governor-General performs his role with the advice of ministers whom he chooses and who hold office during his pleasure. Now this picked up wording from section 64 of the Constitution. Ellicott then criticised the then Prime Minister, Gough Whitlam, stating that he is treating the Governor-General as a mere automaton with no public will of his own, sitting at Yarralumla waiting to do his bidding. Ellicott argued that the Governor-General has clear constitutional prerogatives, including the right to dismiss his ministers and appoint others, and the right to refuse a dissolution of Parliament or of either house. He accepted that these powers are only exercised on the rarest of occasions. He discussed the necessity of a government securing supply, saying, quote, "A government without supply cannot govern. The refusal by Parliament of supply, whether through the House or the Senate, is a clear signal to the Governor-General that his chosen ministers may not be able to carry on. In the proper performance of his role, he would inevitably want to have from the Prime Minister an explanation of how he proposed to overcome the situation. If the Prime Minister proposed and insisted on means which were unlawful or which did not solve the problems of the disagreement between the houses and left the government without funds to carry on, it would be within the Governor-General's power and his duty to dismiss his ministers and appoint others," unquote. Ellicott went on to discuss what information the Governor-General should require from the Prime Minister. He also observed that if the Prime Minister proposes a half-Senate election, then the Governor-General must be satisfied that there will be sufficient supply to cover the election period and that the election is likely to resolve the differences between the houses by giving the government a majority in the Senate. He said that the Governor-General would need to factor in that some states may not be prepared to issue the writs for an early half-Senate election and the legal challenge also that had been made to Senator Field's seat. Ellicott also considered that the Governor-General should consider whether the dispute could only really be solved by a double dissolution. The most controversial part of the Ellicott opinion lay in its concluding observations. He said, quote, "If the Governor-General was not satisfied that the government would have supply until the election results in the territories was known, he would only have one option open to him in the interests of good government. He is entitled to and should ask the Prime Minister if the government is prepared to advise him to dissolve the House of Representatives and the Senate, or the House of Representatives alone, as a means of ensuring that the disagreement between the two houses is resolved. If the Prime Minister refuses to do either, it is then open to the Governor-General to dismiss his present ministers and seek others who are prepared to give him the only proper advice open. This he should proceed to do. The proper advice in the circumstances is to dissolve both Houses of Parliament or the House of Representatives alone, with or without a half-Senate election," unquote. This opinion, which was published by a press release, placed the spotlight on the Governor-General and how he might exercise his reserve powers. Whitlam not only claimed that Kerr must act on his advice alone, but he also claimed that the Governor-General had no right to ask the Crown Law officers for legal advice. He said that any request for legal advice had to be made to the Prime Minister, and legal advice would only be provided to the Governor-General at Whitlam's discretion. Having received a copy of the Ellicott opinion on the 17th of October, Kerr asked Whitlam for legal advice about it on the 21st of October. Whitlam agreed to seek the advice, but said that whether he would pass it on to Kerr was a matter for Whitlam's discretion. Kerr considered that Ellicott went too far in claiming that Kerr had a duty to dismiss Whitlam. On the other hand, he thought that there was a risk that the Crown Law advice would go too far in the other direction, denying the existence of the reserve powers and treating the Governor-General as a vice-regal puppet or automaton. Kerr considered that such powers could be used in extreme circumstances, and that the real question was whether he should take action before the money runs out rather than after, and while the Senate is only deferring supply rather than formally rejecting it. Even though Kerr asked for the advice on the 21st of October, it was not provided expeditiously. A week later, on the 28th of October, Kerr saw the head of the Attorney-General's Department, Clary Harders, at a reception. He inquired when the advice would be presented to him. Harders became worried by the delay. On the 3rd of November, Harders prepared a memorandum advising that Kerr be given formal advice as early as possible this week. It recognised that Whitlam took the view that the Governor-General had to act on the Prime Minister's advice and therefore could not act as an arbiter in the conflict. It also took the view that the stage had not yet been reached when the reserve powers could properly be invoked by the Governor-General. It observed that if the Prime Minister were to tender advice formally to the Governor-General now, it could fairly be anticipated that the Governor-General would accept the advice and act on it. Harders considered that the Prime Minister's advice should be accompanied by opinions from the Attorney-General and the Solicitor-General on Ellicott's opinion, as well as the plan to use the banks to pay public servants. He observed that Fraser had said on a number of occasions that he would accept a decision made by the Governor-General. The department sought to diffuse the crisis by providing Kerr with this formal advice, but unfortunately ministers were less interested and Kerr was left hanging. A frustrated Kerr finally called in the Attorney-General, Kep Enderby, on the 6th of November to get a response. Enderby turned up with two documents. One was an unsigned opinion on which Enderby wrote draft about the legality of the proposed scheme for the banks to pay public servants by way of loans once supply ran out. I'll deal with that in a separate video. The other, more critical document was an opinion concerning the Governor-General's reserve powers. It was signed by the Solicitor-General, Maurice Byers, but not by the Attorney-General. The Attorney-General said that he had not carefully read it. He then struck off the signature, inserted the word draft in the heading, and said that the opinion was to be treated as background only. He said that it contained the views of Mr. Byers, but that there were sections of the opinion with which he did not agree. He said that a final opinion would be provided later to the Governor-General. Sir John Kerr observed, quote, "I must say that to receive on 6 November from the Attorney-General of Australia on two crucial areas of policy at a critical time, those two unsigned, inconclusive draft opinions was not particularly helpful. I found the lack of properly provided assistance deeply disquieting," unquote. As mentioned in previous videos, Kerr had already come to distrust the advice that he received from the Crown Law officers, and this experience of disregard bordering on contempt did not improve things. Kerr never received formal legal advice from the Whitlam government about his reserve powers, and this was a huge strategic error on the government's part. Harders later described the failure to provide timely legal advice to the Governor-General as absolutely incredible. John Menadue, the Secretary of the Prime Minister's Department, later said that the request for advice was badly handled and that there was too much delay from the Attorney-General and the Solicitor-General. Yet Byers had produced and sent an early draft of the opinion. The fault lay with the Attorney-General, who left it lingering on his desk for days on end. Paul Kelly and Troy Bramston wrote that a competent government would have delivered such advice promptly, clearly, persuasively. How could such a request be mismanaged? How could its significance be missed? How could it be that the Governor-General would be treated with such disdain? They concluded that the government's ineptitude was hard to grasp and that Whitlam had failed by shunning engagement with the Governor-General as well as persuasion. So, what was in this draft opinion? Well, Byers accepted that there was a reserve power for the Governor-General to exercise discretion by refusing a dissolution. To positively grant a dissolution, however, the Governor-General must act on ministerial advice. Byers asserted that such ministerial advice comes from the ministers chosen from the political party with a majority in the House of Representatives. He said the only exception is the doubtful case of the forced dissolution, in which case the Crown dissolves Parliament upon advice of a minority ministry. Now, that's a rather peculiar argument. To state the obvious, governments do not always have a majority in the lower house. Minority ministries do exist from time to time and can properly advise a dissolution, as can indeed a government that has been defeated on confidence in the lower house. The long-standing convention requires that if a government has lost confidence in the lower house, then it must either resign or secure a dissolution. While a Governor-General could, in such circumstances, refuse a dissolution and appoint someone else to form a government, if that were possible, the more common approach is to accept the advice of a minority government for Parliament to be dissolved. Ultimately, Byers disputed the assertion by Ellicott that when the grant of supply is deferred by the Senate, the Governor-General is constitutionally obliged immediately to seek an explanation from the Prime Minister of how he proposes to overcome that situation. He also disagreed with Ellicott's view that if the Prime Minister were unable to resolve the problem and the government was left without funds to carry on, it was the Governor-General's duty to dismiss his ministers. This disagreement essentially concerns the exercise of discretion, including the point at which it should be exercised. But that discretion is vested in the Governor-General and is not a matter for legal advice by the Crown Law officers. The opinion, quite impractically, argues that the Constitution provides a mechanism for resolving the deadlock over supply through the Section 57 process. Section 57 provides for deadlocks between the houses over bills to be resolved first by the full dissolution of both houses and an election, and then, if the government is returned and the bills remain blocked, by a joint sitting. The process takes a long time because there must be at least 3 months between the bill being blocked at the first occasion and being resubmitted to the Senate for consideration on the second occasion. If you had to go through the full process, including a joint sitting, it would take between around 6 and 9 months to resolve, all while there was no supply. For that reason, it's never been seriously contended that a supply crisis could be resolved by the Section 57 process. After the dismissal, there was some selective quoting from the buyer's draft opinion, suggesting that he had advised that the reserve powers did not exist. As a consequence, the new Liberal Attorney General, Sir Ivor Greenwood, publicly released the opinion with buyer's consent. Greenwood pointed out that Byers had himself indicated that he accepted that the Governor-General had a reserve power to dismiss Whitlam. Byers later observed that the question had never been the existence of the power, it was a matter of whether it ought to have been exercised at the time and in those circumstances. In a 1983 opinion, Byers confirmed this position, asserting that Kerr's power to dismiss Whitlam existed and that the power was the Governor-General's alone to exercise, not the Queen's. But he confirmed his view that there was no duty to exercise the power. It was a matter of discretion. When the Secretary of the Attorney-General's Department later said to Kerr that he thought that a forced dissolution could only be precipitated in extreme circumstances and that he didn't think the circumstances upon which Kerr had acted were sufficiently serious, Kerr responded that he had never sought an opinion about how he should exercise his discretion. He had only sought advice from the Crown Law Officers about the extent of his powers. His discretion was a matter for him alone. There are perfectly legitimate grounds for disagreement about whether Kerr should have exercised his powers in the relevant circumstances and at the time that he did. But from a legal point of view, he clearly had the power. As for the discretion, it was vested in him. That's why we appoint senior and eminent people to hold the office of Governor-General in the hope that if they ever need to, they will exercise that discretion wisely. Thank you for watching the Constitutional Clarion, and I look forward to seeing you again next time with another episode on this Whitlam dismissal series. See you then. Goodbye.